Hi, everybody. It's lovely to have you here with us today. We have a fantastic set of speakers that are going to bring to you different angles in discussing the child's right to identity in family relations, as well as talking to us about how to access justice and effective remedies when this is not respected and it's not possible. What we will be doing today is we have our list of speakers, and we won't be going into detail in terms of their bios, but they will be put up in the chat function so that you can have access to those. All the information about this webinar series is also on the website, which will be also added in the chat function. And so without further ado, I'd like to introduce to you our first speaker for today, which is Natalie Lewis. Welcome, Natalie, from Queensland in Australia. Natalie is the Queensland Commissioner for Children, and we're really pleased that you could join us today. Thank you, Natalie. Over to you.
Thank you. Thank you for having me. Amalia. My name is Natalie Lewis. I'm a Gamilaroi woman and I'm a commissioner with the Queensland Family and Child Commission. I have an explicit focus in the work of my team, where we're focused on the protection and promotion of the rights of children, and particularly a focus on First Nations children. And so I'll share my screen if I can figure out how to do that. There we go. Share. There we are. Okay, are we good? All right, so if I'll just start off by an acknowledgement of country. We are here at the moment in Meanjin in Brisbane on the lands of the Yagara and Turrbal peoples. So I just pay my respects to their elders, both past and present. Today I'm going to talk to you about the Aboriginal and Torres Strait Islander child placement principle. Now, I have never tried to explain this in 10 minutes previously, but I'm going to absolutely do my best. But realistically, if we think about it in terms of the stolen generations, what happened here in Australia, people like to think of that. I think it gives them comfort to think that this is, hundreds of years ago. But the truth of the matter is, under those previous laws, the last documented removal of an Aboriginal child was actually 2 years after I was born. So when we think about the recency or the proximity to such aggressive policies of forced removal of our children, the only thing more heartbreaking is to imagine that today there are far more children being removed. The rate of removal and the number of our kids living in out-of-home care with non-family members disconnected from their kin, country and culture is far greater than at any time during the stolen generations. So as a result of some of the grassroots advocacy that happened sort of in the 1970s, and then sort of fast forward to a landmark inquiry into the stolen generations, the recommendations that were contained in the Bringing Them Home report really agitated a number of a bit of legislative reform across all jurisdictions in Australia, where they adopted what was known as the Aboriginal and Torres Strait Islander child placement principle. Now, when that was originally introduced into legislation, it was effectively a placement hierarchy that drew very much on the legislation from the US. So it was really talking about when an Aboriginal child is removed from their family, that there's a preferred hierarchy of placement. So placing within their family as a second option with community members within, on country, and it starts to progressively go down a list until you arrive at a place where there is absolute disconnection from kin, country and culture. Now, unfortunately, what we've seen is that still the majority, until probably the last 5 years, the majority of Aboriginal children would find themselves very much at the bottom of that hierarchy in terms of longer term placements. So significant impacts in terms of, impacts in terms of their identity, their connection, and really the loss of language, culture, and those relationships that are so critical for children of culture. So when in about 2012, we were involved in a review that was done around the implementation of the child placement principle. Now, what we found in that is that it was It was problematic in that it was one-dimensional, and it really only forced a statutory system to think about an Aboriginal child's identity or their right to cultural continuity after they'd already made a decision to remove the child from their family and community. So when we looked back and the testimony, the things that were sort of brought to our attention in the Bringing Them Home report, what we realized is that what it eventuated in terms of the placement hierarchy fell really well short of the intent of bringing them home. So what we had proposed in that review was that there were actually 5 constituent elements of the child placement principle. So I'll bring those up in a second, but effectively in 2015, that was then adopted as national policy, that there was recognition of the 5 elements, not just a simple placement hierarchy. And in 2016, the jurisdiction that I'm in, Queensland, became the first to legislate all 5 elements of the child placement principle and recognise that needed to be applied at every significant decision in relation to an Aboriginal or Torres Strait Islander child, primarily for the purpose of safeguarding their rights to connection and cultural continuity. Between 2017 and 2020, there were a number of other legislative reforms. The first being active efforts, so introducing a legislative standard of active efforts rather than just what is reasonable or practicable, because a lot of the time that's a pretty easy opt-out clause for implementing the child placement principle. So the move towards active efforts meant that every decision and every action has to demonstrate that it's purposeful, timely and thorough, which is a really different legislative standard than exists typically in legislation in child protection in Australia. The other really important thing was recognition of best interest being an enduring right, that it wasn't just about best interest at a single point in time for a child, that it was recognizing that as a statutory agency in intervening in the life of a child, you had to think about what is in their best interest now and for the duration of that child's life. So those things combined with the principles make a fairly significant difference in terms of the onus on the state to make decisions that are far less likely to adversely impact the long-term identity and connection for Aboriginal and Torres Strait Islander children. So I'll jump to, these are the 5 elements. So what we think of that as the key legislative and operational safeguard for the rights, including the distinct cultural rights of Aboriginal and Torres Strait Islander children and young people who are involved with or at risk of involvement with the statutory child protection system. The first element is prevention. So that recognises a child's right to those relationships, to grow up safely in family connected to country and culture. Prevention is about taking active efforts to make sure that families have access, equitable access to the types of universal supports and services that they need to keep children safe at home. The second one is about participation, and that elevates the right to participation of a child and of their family in making decisions about their immediate and long-term best interests. The partnership element is a requirement on the state to recognise the role of Aboriginal community-controlled organisations. So self-determining organisations that participate in the design and the delivery of services that are meant to benefit Aboriginal and Torres Strait Islander children and their families. The placement hierarchy is quite similar to what originally existed in legislation, but the final one is connection, and that's recognising that right to cultural continuity, but it's also a reinforcement of the right to, those familial relationships, the right to learn language, the right to, permanency that is about not just their relationships, but the environment, the connection to country that is so critical to their well-being. So when we emphasize connection as part of all of the decisions that are made, it kind of lifts the threshold a little bit and makes it a little bit more difficult to make random decisions, spur of the moment decisions to sever those connections for Aboriginal and Torres Strait Islander children. We haven't got as far in Queensland as enforcing or pushing for a duty to act or in incorporating penalties or, legal obligations in terms of faithful implementation of the child placement principle. And that's where we see, I guess, one of our biggest challenges is making sure that any Aboriginal or Torres Strait Islander child, irrespective of who their worker is, what part of Queensland that they live in, that their rights are respected and that they are actively protected through the application of the child placement principle. So am I under 10 minutes yet? I'm
You
pretty sure I must
are.
be
You
pretty
are
close
under
to the
10
mark.
minutes.
Yes, but that is probably the fastest that I've ever gone through that. But I'm happy, yeah, if we want to have some questions, or you're in charge, Mia, if we're moving
Okay.
on to the next speaker.
Thanks. What we might do is exceptionally have questions for you, Natalie, so that you can leave and go to bed, because it's very late for Natalie, and they're about to have a cyclone. So if anybody has any questions, please put them through in the question and answers section, and then we give Natalie a few minutes to answer any questions that might be there. But I do love the fact that this best interest principle looks at not only the child's short-term needs, but going into the future, because that, I think, what we see in many cases is everybody thinks immediately these are the child's immediate needs, without looking at, is this still going to be in the best interest of the child in 5 years, in 10 years' time? I see no questions, but let me ask you a question about the faithful implementation of these principles that you mentioned. Do you see a way in which, if these principles weren't implemented for a child, what would be a child's way to access justice in the Queensland system? Where could they complain?
Yeah. Unfortunately, I mean, we have a number of avenues of complaints. None of them are necessarily fit for purpose when we're talking about children and the immediacy of the response or remedy that's really required. So when young people are, children and young people are trying to raise a concern, even when they're aware that they can, or who they need to contact, a lot of the time, the process of like moving complaints through a system means that takes far longer, than sometimes what is just a common sense, decent response to a child to fix a particular situation, and so I understand that there's some work being done. We've just had a change of government here, that there is an interest in revisiting and looking at accessibility around complaints for children. But I think one of the things that is sadly missing in Queensland, and actually in a lot of jurisdictions, is the availability of individual advocacy that is not purely legalistic for children. So system-facing advocacy that can engage, excuse me, and advocate across systems and portfolios on behalf of that child. And so at the moment, we tend to view that only in a legal sense, and where we look at advocates in during court proceedings. But I think that having access to that practical, independent point of advocacy, making that accessible for children, that they're known to children, and they're not trying to carry caseloads of 600. I think that that would make a real and meaningful difference in children, building that confidence in the system, not their own confidence to advocate, but the confidence that the system actually would listen and respond in a way that's meaningful.
Thanks for that, Natalie. That's super helpful. I think that it's true. It shouldn't just be focused on legal, because it is much broader for all these children. All these issues talk about their mental health. It talks about their cultural connections, like you were talking about before, learning languages, environment, community. So it would be helpful if, hopefully, the general comment that the committee is drafting will be able to focus on something broader than the legal stuff. And I'm sure Anne will speak about that later. So thanks for that, Natalie, and good luck with the cyclone.
Thank you.
But now let me go to another colleague from Australia. Now we have Linnell Long with us, who is the founder and the director of Intercountry Adoptee Voices. She's with us from Sydney, and she's going to be speaking to us about children that have accessing their, not just children, but adoptees, access to justice and remedies for adoptees. Thanks, Linnell, over to you.
Thanks, Mia. You can hear me?
Yep,
Yes,
but just a
great.
bit softly. So maybe if you want to just increase the volume a little bit.
I'm not sure how I can do that,
Maybe
but I will speak louder.
it's perfect. Thanks.
Okay, great. Thanks for having me, Mia, and the team from CHIP for making this possible and giving me the opportunity. Yes, as Mia said, my name is Linnell Long, and we don't stay children forever as adoptees. We actually grow up. I'm an intercountry adoptee born in Vietnam, and I was flown to Australia in the 1970s. I'm the founding director of a global network, started here in Australia, but it has, quickly became global, and that is called Intercountry Adoptee Voices, which is a space where we provide peer support to each other and advocacy as intercountry adoptees born from any birth country and adopted to any adoptive country. I'm going to talk briefly about who our community is and the global issues we face for which we need access to justice and reparation. I'll also speak about some of the solutions that we've already had around the globe, plus the most important one, which still remains unaddressed. So who is our community of intercountry adoptees and what are the problems that we face? Well, we are an estimated, as a minimum, 1.2 million people adopted across many countries since 1948. Within my ICAV network alone, which is a global one, we are born from at least 49 birth countries and we get sent to 16 adoptive countries. Our largest cohort is the South Korean group. They are at least 170,000 as a minimum, sent since 1953. And the largest receiving country is the United States, who has just over half of those 1.2 million adoptees globally. We are born in one country, and because of a wide variety of situations, we end up being displaced to another country. We get removed from our culture. We get adopted mainly to genetically unrelated people who are ethnically of a different race to us. During the adoption process, we have our identity and our origins removed, and this gets replaced with fictionalized data. For most of us, our ability to know that original identity remains a mystery for a good portion of our life. Barriers are actively in place that prevent us from accessing our origins information. These barriers are things such as language, physical distance, culture, legislation, and finances. Within ICAV alone, my network, we have 7% of adoptees who have no desire to search from their family. So a good majority want to. 51% have found their family, whereas the other 40% would like to, but have found nothing because of the barriers. Only 1% get found by their biological family, and 2% had an open adoption, so didn't need to search. We are impacted emotionally throughout our lifespan, and research suggests that we suffer suicidal rates at between 3 to 6 times higher than non-adopted people, and up to 6 times overrepresented in mental health clinics. Not knowing our origins, dealing with the ongoing barriers, it impacts us significantly, and we spend our lifetime trying to find out who we are and why we were displaced. Post-adoption services vary by country, and despite Hague countries reporting that they provide post-adoption support, it's often a very different reality for adoptees. In Australia, for example, we have funding of $950,000 per year that gets provided to all of those who are impacted by intercountry adoption. The level of insufficient funding is obvious when you actually consider that there are over 15,000 of us, which means if you divide it between all of us, there's about $63 per adoptee per year. This does not even cover the cost of one counselling session with a psychologist. Legislation in intercountry adoption is also written to support mostly the needs of the adoptive family, not the adoptee nor the biological family. For example, up to 44% of Hague signatory countries advise that they provide legislation to annul or revoke an adoption, which I believe should be a basic right for all adoptees. Yet in reality, it can be vastly different. In the USA, for example, despite reporting to The Hague that they have legislation in place for this, in practice, only 3 out of 51 jurisdictions allow an adoptee to undo their adoption. Some of the worst case problems that exist globally for our community who want to access to justice and remedies are those who suffer abuse and neglect within their adoption. The latest and most recent human rights study of 658 Korean adoptees shows that 1 out of every 6 gets sexually abused, and 1 out of every 3 has experienced some form of abuse within their adoptive family. I published our global first paper in November last year, highlighting the sexual abuse within intercountry adoptive environments and what needs to be done to prevent and respond to these additional traumas. The other worst case scenario problem that our community faces, which is very specific to the United States only, is those who lack citizenship and get deported back to their country of birth many, many decades later. The USA lacks legislation to ensure automatic citizenship for intercountry adoptees who arrived prior to 1983. Tens and thousands of adoptees that this impacts, they face legal quagmires of having conflicted residence status, being unlawfully present, having missing or fabricated documentation, and they can face criminal deportation. And I know numbers of them who have. Those who are deported, they struggle in their countries of origin because they have not grown up there, they do not speak the language, they don't have any ties, their legal ties were severed, and there is very little to no support for them. Then there are those of us who had adoptions that were illicit and illegal, and that's been hitting the media a lot lately in the last 8 to 10 years. The UN has worked with our community extensively in this period as well to understand the set of issues and outlined all of the requirements that we would hope states would live up to in the joint statement on illegal intercountry adoptions that was issued in September 2022. For all of these worst case problems and the big picture issues, adoptees lack many protections. Countries usually fail to provide access to justice and remedies, and there is no independent monitoring of countries to ensure that their responsibilities are met, despite being signatories of the Hague or the UNCRC or any other convention like the Convention of Enforced Disappearances, nor is there any enforcement or complaint mechanism for us. I have presented to you that high-level sample of a global picture from the intercountry adoptee community, which I am very connected to on a daily basis. And what I want to point out is that there is a huge gap for those to understand the biological family perspective and their needs and rights. So I hope you'll consider that despite me not talking about it, because it's not my lived experience, but we definitely need to make sure that on the agenda, we look at what do biological families need to access justice and remedies, particularly when they are the least empowered. I will now discuss 5 remedies that have been provided for victims around the world so far. Some countries are stepping up and starting to do some of this, which is fantastic to see. So in the European Union, Belgium is the first country in the world to create legislation that includes illegal intercountry adoption as child and human trafficking. This is immensely important so that perpetrators can be held to account and so that victims can be recognised. Another country, South Korea, as a birth country, is providing an independent investigation called the Truth and Reconciliation Commission. And they're reporting on the history of Korean intercountry adoptions and providing recommendations for their victims. Their report is actually due next month, so the world is sitting with fingers crossed, hoping for good news. I actually know it, but I can't say. But the concept of investigating for truth, apologising and compensating needs to be available for all victims around the world, not just in Korea. In criminal cases where child trafficking is proven, we need to include restitution processes. So the first example of this happening is actually in the United States in response to the Samoan illegal intercountry adoptions. Traffickers had to actually put dollars into a trust fund that was administered for the victims to give them access to return to the country and keep connected with their birth families. In one case, out of all of those adoptees that were impacted, the adoptee was actually allowed to return to their birth family. And I say this needs to be much more of an option, much like where a divorcing couple breaks up, the child is facilitated to live between the two families, and it should be across 2 countries. Another example is that governments and entities should fund search and reunion services for all victims of intercountry adoption. The best case is to fund adoptee-led organisations to do this, and currently there are 2 governments in the world who are funding adoptee-led services to do that. The Swiss government is funding Back to the Roots, a Sri Lankan adoptee org, and France is funding an Ethiopian adoptee-led org to provide this. This is great. Legislation also needs to be put in place to allow things like the right for adoptees to discharge their adoption, especially if an illegal adoption or abuse or neglect has been happening, and that should be at no cost to the adoptee. Australia actually has this in place, and I'm actually one of the few intercountry adoptees in Australia to go through this procedure and annul my adoption. As adoptees here, we can choose to revert to a name of our choice, and we get to retain the benefits of such as citizenship, which we gained through adoption. The most significant remedy that is still needed globally is that countries do not often have procedures for the enforcement of the UNCRC's Article 8 request for our right to identity. Peter Moller from Danish Korean Rights Group, he's the one that's been leading the work in Korea to help the truth and reconciliation process happen and to bring to light all of the information that's actually there as artifacts for what's been going on for the human rights abuses. I'm actually going to share some of his speech that he spoke when we originally did this presentation because it's quite succinct and good. So he said, adoptees are looking for true information about our background, not the fabricated information that was done to make the procedures and the transactions of our adoptions possible. We are looking for our correct information. Adoptees around the world invoke Article 8 of the CRC. We do this as requests to adoption agencies that withhold our personal and intimate information. We go to the authorities in our adoptive and birth countries, and we ask them to live up to the convention that they've ratified. Seen from the outside, the Conventions on the Rights of the Child is a success. Where do you find a convention that most countries have signed, ratified, and committed to comply with? This should be the best starting point for adoptees, but the reality is, unfortunately, quite different. Adoption agencies consider their records on us to be their private property, which we cannot access. The authorities in both sending and receiving countries do not have systems or procedures for handling or enforcing Article 8. In cases where adoptees have been stolen, lied, taken as stillborn children with written admissions from adoption agencies that their adoption papers are falsified, the authorities in both the donor and recipient countries are found to be quite passive. The states do not initiate fast recovery of adoptees' background and their true information and identity. Instead, the authorities of each country point out that it's the other's responsibility because they do not have jurisdiction over each other. Adoptees need Article 8 on the Convention of the Rights of the Child to be addressed. Specifically, we need countries to cooperate amongst themselves legislatively to ensure the enforcement of rights. We need the states to organise themselves in terms of authority and administratively to ensure the fulfilment of these rights. And we need states to create procedures and actions to demonstrate how they comply with the enforcement of rights. We also need the UNCRC to develop guidelines and clarify the purpose, content, and scope of Article 8 that can contribute to the enforcement of rights addressed to adoption agencies and state authorities. Article 8 is one of the most important rights for adoptees, and both time and hope are running out because as adoptees get older, so do the biological families and our chance of ever finding them. Thank you for your time. I hope this presentation has been informative for you. Thanks, Mayor.
Thanks for that, Lynelle. As always, very powerful. And I think that Article 8 is very important for intercountry adoptees, but it's also very important for the children that Natalie spoke about, the Indigenous children that have been removed from their families unnecessarily. And as a bridge, I would like to introduce us all now to Patricia Carey, who also speaks about another group of children that have also been unnecessarily removed from their families, which is not only occurring in Ireland, but also in other countries from single mothers. And some of these children were adopted internationally into other countries. So it does also affect the children in Ireland who were adopted into Australia, into the USA, into the UK. And so we really do need some more guidance on Article 8. But over to you now, Patricia, who is a special advocate for children that are part of institutional abuse in Ireland. And if I could just remind people that are listening in on this webinar, if you do have questions, please put them up in the question and answers section on the website, on the webinar, and just say who the question's for, and then we can, because we will have about 25 minutes at the end for questions. So over to you, Patricia. Thanks for
Thanks.
sharing.
Thanks, Mia, and thanks very much for the invitation. Can everyone hear me okay? Sorry, I was slightly late there. I got caught with something. So thanks for Mia's introduction. My role, I was appointed by the Irish government as the first special advocate for survivors of institutional abuse and forced family separation. And just to give you, I suppose, a very quick context in terms of numbers, when the Irish state was founded in 1922, from that date to 1998, over 200,000 people were in institutions. So they were what they were called mother and baby homes, or institutions as we now call them. Over 46,000 women, about 55,000 children born in those institutions, another 12 to 15,000 women who were in what is called Magdalene laundries, where they forcibly worked for no money, and about 50,000 young people, children under 18, who were put for petty crimes or for living in poverty into industrial, what they were called schools, but these were really prisons for children. And then a whole range of other children who were illegally trafficked, primarily to the United States, but to other countries, children who were fostered or boarded out to families to work. So the remit covers about 200,000 people, also those living abroad. So it's a fairly wide range of work. But I wanted to talk about what we call non-recent historical abuses, particularly in respect of forced family separation and the effect that that has not only on the individual itself, as Lynelle said, but their, intergenerational suffering and trauma. About 15% of the people that I interact with are family members, so sons and daughters of those who were forcibly removed from their family of origin. And excuse the language, so I use the term family of origin or first family, but I'm also open to any other terms that people feel comfortable with. The biggest issue for those people is not financial redress, and the Irish state has had 4 large, what they call redress schemes or compensation schemes. Most people who receive that money say they're not interested in it, or it doesn't in any way affect their quality of life or the trauma that they suffered. What we say is that financial redress is just one part of a whole suite of redress measures, and that would include access to genetic medical counselling. We have a huge concern for people who with unknown genetic medical histories. So they, I'm doing some research on that in Ireland, but also then in terms of records. And that was the key thing I wanted to talk about. Unfortunately, some of you may know that the Irish state was primarily governed, although we had a democratically elected government, but the church, the Catholic Church in Ireland, was where they were the people who ran most of these institutions and had control of them. And mind-bogglingly, we still don't have the files and records from all of those church bodies who ran the institutions. And that's part of the work that I'm doing as special advocate, is to campaign and lobby. So we recently passed legislation in October of last year called the Preservation of Records Bill. Now, it didn't go far enough, but it said that anyone holding records related to adoption or forced family separation, there was a penalty of law if they destroyed or moved those records outside the state. So the next step is to get those records in. I would say 2 out of every 3 people who contact me don't have full access to their records. They may have received partial records with redactions, or they haven't received the full extent of their records. And as Lynelle said, an aging population, I would deal with people right up to their 90s who are still living in hope that they may be reunited with their son or daughter, and hope fades as time goes on. But those records are key to that. So there are other things that the Irish state is doing. So we have a financial redress scheme for those who were born in mother and baby institutions. Unfortunately, in their wisdom, the government decided to exclude 24,000 children from that scheme. And there was a public statement made in our parliament to say that children under 6 months couldn't suffer trauma, so therefore they were not part of the scheme. Obviously, that is one of the biggest things that I'm lobbying policymakers and opposition politicians to change. They also defined a very narrow set of institutions. So in Ireland, there was a network of trafficking. Women went into one institution, they had a child, the child was trafficked to another institution. So we know now that there was over 200 institutions in Ireland where women went from a mother and baby home to a Magdalen laundry, and maybe their children then went to an industrial school, largely based on social class, poverty, maybe where one parent died, because of, in Ireland, our social welfare system really only began to be properly developed in the late 1960s and 1970s. And interestingly, in terms of domestic infant adoption, it wasn't until 1973 when the state introduced what they called an unmarried mother's allowance that domestic adoption fell off, and children were parented by their own parents. So we also had situations where large numbers, and we still don't know the full extent because of the absence of access to files and records, were illegally trafficked to other countries. And not only illegally trafficked, they were born in Ireland, sent to the United States or other countries, and then registered as a child of that country. So they lost their heritage, they lost all record of their family of origin. And I've recently been to the United States to meet some of those people who are, you know, just suffering immense trauma in not knowing and not having their heritage respected and honoured. And quite frankly, you know, criminal acts took place. There were also groups of children where there were vaccine trials. So we know that a number of pharmaceutical companies got state permission, because these institutions had large cohorts of children, to conduct quite questionable trials in terms of drugs that were being tested, baby milk formulas that were being tested. And this took place over the 50s, 60s, and right into the 70s. And to this date, that cohort of people have not been recognised, properly medically assessed, or any acknowledgement from the state that the state should sue the pharmaceutical companies in order to give them medical support and financial redress. And those people are then excluded from other redress schemes, because if you receive a compensation payment, the state says you must sign a legal waiver that you will not take any further legal action on any matter related to your adoption, your time spent in an institution. So as I say, the intergenerational trauma for children and now grandchildren seeking records related to their parents' time in an institution has become quite a significant part of my work. And I would spend a lot of time both talking to individuals to gather oral history, oral testimony, but also working with academics, activists, policymakers in order to effect change. Mia, I'm not sure if you want me to say more about it. In my previous work, I worked in adoption, so I'm very familiar with Lynelle's world, and I'm a little bit of a poacher, gamekeeper turned poacher, because I was the CEO of the Adoption Authority of Ireland for 9 years. But I went in, I suppose, with the intent to push forward legislation that was enacted in 2022 for the first time, that people who were adopted could have access to their original birth certificate, birth and early life information. And it is quite astounding that only took place 3 years ago, that people could have access to that information. But I would agree with Lynelle, having worked in the inter-country adoption space, that there is a huge sway of strength and activism coming from inter-country adopted children, now adults, that they have an absolute fundamental human right to all of the information in respect of their birth, early life, their being moved from one country to another, and also rights to primary identity. As I say, I'm happy to take any questions later on and engage with people individually after the seminar. Thanks, Mia.
Thanks for that, Patricia. It's one of the many reasons why we asked you to participate, because of your wealth of knowledge, and also because of this unique role that I hadn't seen in any other country, of having a special advocate specifically for the children and for their families that had been affected by this institutional abuse. So I think it's a very creative way to have some representation for their voices. So we will have questions for you, Patricia and Lynelle, afterwards. But moving on now, to Arthur and Audrey Kumalvasan, who are also children that were affected in terms of their rights to origins and rights to know how they were born and their origins, but are adults. And so it really is, the aim of this webinar is to really show that you don't stop, the child's rights violations don't stop having an effect when you turn 18. They continue on after as an adult, and as Patricia has been talking about, and can affect future generations. So it's really something that's important that we work on. But over to you, Arthur and Audrey. Thank you. Audrey, juste que tu saches, on voit les... Oui, c'est mieux. Parfait.
Okay, first of all, we would like to warmly thank all the organizers of this event, and especially the members of CHIPS, Child Identity Protection, and all the panelists, and especially Anne Skelton.
We would like to start with two quotes which well illustrate our point. A society is judged by the fate it reserves for its children. A homeland without justice is a prison.
Okay, just we will talk about knowing one's origins and access to justice.
But before presenting why we are in front of you today, we would like to introduce ourselves. We are both donor conceived from France, like 100,000 others in France, and like more than 8 million people around the world. We co-founded Origins Associations, which has the goal to help people who are searching their origins, not only donor conceived people, but also, for example, people born under X. That means that the mother has chosen to keep her identity a secret.
In France, like in each country that practices donor conception in the past, the secret was recommended. They chose a donor that looked like the infertile parent, same skin color, same hair color, same eye color, same age, same weight, and same blood type. The goal was the child would never know anything, never know that they are a donor conceived person.
I always knew that I had a donor.
Yes, you're an exception.
It wasn't a secret, probably because my mother is psychoanalyst. My parents chose to tell me the truth about my conception and my father's infertility. During my childhood, I was convinced that one day my parents would introduce me to my donor, but that day never came. So when I was 19 years old, I told them, okay, now I'm an adult. You can give me the file and the donor's file. My parents were sorry. They explained to me that they didn't have a file. In 2006, I was 26 years old. I began to testify publicly of my need to know who my donor was. In 2017, through a DNA test both on the web, even though it's illegal in France, and we will come back to that later, I found my donor in 11 hours. I discovered Gérard, my donor, lives 150 kilometers from us. Arthur and Gérard.
Me, as far back as I can remember, I've always believed in justice, and now I'm not sure. Because when I chose to specialize in bioethics law, I didn't know that I've been conceived by a donor. I discovered it when I was 29 years old, and I found myself confronted with a multitude of questions. And that's why I turned to law, because I knew that the right to know the identity of one's parents is provided for in international and regional text, in the Article 7 of the CRC, in the Article 8 of the European Convention on Human Rights, and the European Court of the Human Rights say that Article 8 includes the right to know one's biological parents. So I went to French court because I knew that the first laws governing donor conception dated from 1994. That means 14 years old after my birth. So I asked the French hospital if my brother Peter and me have been conceived by the same donor. And then when Arthur became my fiance, if we have the same donor. I also asked them to contact my donor and to ask him the question if he would like to give his identity or photo to me. I also asked for non-identifying data, piece of information such as the numbers of my siblings and my donor's personal and family medical history. Everything was denied. I lost each trial. They even refused to tell us before we married if we had the same donor with Arthur. So I went to the European Court on Human Rights. I appealed to the European Court on Human Rights in 2016, and my case was judged on September 7, 2023. And during that time, French law has changed in 2021. But for me, you'll see nothing has changed. Because I submitted a request to the new commission in October 2022, and the French administration finally sent me a letter in March 2023 to tell me that my donor is dead, 14 years after my first application. And they added that they can't give me any information because the donor didn't consent before dying. So I can't know if my brother and me have been conceived by the same donor, if my husband Arthur and me have been conceived by the same donor, if I have siblings in nature, and how many and who they are, and they are probably a lot because I knew that my donor has been paid for his donation. And I can't know the medical history of my donor's files, even it's still in the French hospital. And finally, European Court on Human Rights judged my case in September 7, 2023, and they say there is no violation of Article 8 of the Human Rights Convention because they consider there is no European consensus in favor of recognizing for each person a right to know one's origin, but only a recent trend in favor of this right. They added, French legislator was guided by the will to respect the situation arising around the influence of previous texts, and that they didn't see how he could have done otherwise. But they forgot that before 1994, there was no text. And even afterwards, the principle of anonymity only concerned the donor and the recipient relationship. The child was never targeted by the text, the French text. But this is for the justice, and this is in reality, because, I finally made a DNA test, even though it's illegal in France, because I lost each trial. And finally, thanks to the DNA test and the kind welcome of my donor's family, I discovered who was my donor, and I moved to introduce Philip to you. His family welcomed me, and my family has a chance because Philip died too early and he had no children. Although I'm obviously disappointed he's dead, being able to see his face, to know how he looks like was so helpful, so fantastic. I feel complete. Now, I also know the medical history of the family. For example, Philip's father has had 7 heart attacks and have heart fragility. So what absolutely needs to change? Legalizing DNA testing where it's forbidden, create an international registry for all people who are searching their origins, transmission to donor-conceived people and to children born under X biological parents' medical history, and information about siblings. Remove the possibility of remaining anonymous after death. It's excessive with regard to the balance of interest at stake. And you can remember the case of Jaggi versus Swiss in 2006. The European Court on Human Rights said that the deceased person cannot be affected in his private life because the right to respect for private life dies with its holder.
Audrey, transforming childbirth under X into childbirth in discretion, a high level of protection at birth and anonymity during 19 years maximum, it's fundamental to systematically register the name of biological parents and keep it secret during 19 years maximum. Do the same for donors. Before 1st September 2022, the French legislator chose to limit the access to donors identify only if donor consent when he will be asked for, but before first bioethical law of 1994, there was no legal anonymity. Between 1994 and 31 first August 2022, the French principle of anonymity concerns only the donor and the recipient. It doesn't concern the child who has been completely forgotten. In any case, maintain the ban on establishing parentage by clearly separating the right to know one's parents from the right to establish one's parentage. 1998, old and constant recommendation based on CRC.
Maybe Arthur and Audrey, I'm
Yes.
going to leave that one. If you want to
Yes.
speak, in the question section, I'm going to ask what should we do for in the future, and this would be the perfect time to talk about this, so that we can give the floor to Anne Skelton. But the reason why we have you is because there are so many millions of children born through anonymity, but it's not the only issue for them. It's also the number of siblings. It's also the types of donations that are being used. And I think that there is so much more that is going to have to be done by states in terms of access to justice and remedies for these children. But I leave you to present this part in the last section, if that's okay. But I give the
Thank
floor
you.
now to Anne Skelton, who is going to wrap up in many ways some of the things that have been discussed today in terms of the issues for children in care now, Indigenous groups, but also in care in the past with institutional abuse, like in the case of Ireland, but also in the case of Australia, Switzerland, and many other countries, and also in the cases of intercountry adoption and ART, assisted reproductive technology, and also surrogacy. So this is all about access to justice and effective remedies for children and family relations. So a lot of things to talk about, Anne, but over to you now. Thanks.
Well, thank you very much. And let me first of all say a special word of thanks to Linnell and to Audrey and Arthur, because your stories are so inspiring. And I've heard them before, but I never get tired of listening to them. They are just so important because they really show us how how long and arduous the journey of access to justice really is. So Mia has outlined, some of the bigger conversations that have been happening around the world, where we have seen many states, and we heard a little bit from Patricia about this as well, where states are coming up with solutions or mechanisms for redress in following situations where there have been historic violations and large group violations of rights. And I think this is a very important area of development, which is in need of good comparative research to see what are the outcomes of these processes, how are they benefiting the people who are going through them. And what's very interesting is it's not just a matter of whether there is compensation or restitution at the end of these processes, but also how do the processes themselves provide vindications and solutions that we can see people experiencing justice. So in the Committee on the Rights of the Child is in the process of drafting a general comment on access to justice and remedy. And I hope you'll all be looking out for this when it is put out for public comment, which will be in a few weeks from now. Because in this, there is a whole section on the effectiveness in achieving redress. And this is for all kinds of rights violations, but would include these kinds of broad-scale historic types of rights violations. And under this effectiveness in achieving redress, the committee looks at reparation, measures that are needed to redress violations of children's rights. And of course, as we know, and has been said several times in this webinar, even though the rights violations may have occurred when the people were children, as in below the age of 18, the effects of those violations are continuing, and that they may be any age when they bring their claim or their application to try and seek reparation. Reparation can take several forms, and the general comment looks at restitution. So that is basically about putting people back in the position that they would have been in. In this kind of scenario, that is difficult to do, but at least providing as much information as possible about identity. All of those recommendations, I think, that Audrey and Arthur and the ones that Linnell outlined for us could all be part of a general restitution approach. In other words, reconstituting people's identity. Compensation is also obviously part of the kind of effective redress that would be sought or could be sought. And this might take monetary forms, but it also might take more symbolic forms. And these are, I think, things that can be worked out in the process of these kinds of large-scale justice processes. Recovery and reintegration is another type of redress. And this would, again, be, being provided with support, psychological support, but also practical support in trying to discover identity, in trying to find one's donor, as the stories that we have found, in trying to find the records, in opening the access to the records. What about all of the expense involved in taking cases through several levels of court? In the end, who would be responsible for those costs? Well, it could well be that this might be part of the compensation that would be sought, but also the assistance given to individuals would be part of the recovery and reintegration. Satisfaction is another one of these features of redress. And satisfaction is about the subjective experience of the individual. So what we know is that remedy isn't just about outcomes. It isn't just what you get at the end of the process. It's also about the experience of the process, and that how that can itself be reparative, how that can itself mean vindication, how it can discover the truth. And these are all very important things for victims of the types of violations that this webinar is focusing on. And then finally, the last of this cluster in the general comment is on guarantee of non-repetition. And all of these big, large-scale types of investigations should include all of these features somehow. They may take different forms, they may look different, but it's very important that there should be a guarantee of non-repetition. And this is where it moves beyond reparation for the individuals concerned who brought the claim, who've identified the rights violations, but it's also forward-looking because it can say, this is why we need the law to change. As Audrey was explaining, she's listed, how should the law change? These are the things that need to go forward. Well, part of reparation can be making sure that the law changes going forward. The extent to which law can change things retrospectively is always a difficult debate to have, but one of the things that the general comment does say is that states should consider changing things like statutes of limitations and prescription periods, and this could affect both criminal matters if, for example, there's proof that children were sold or trafficked. One would always have there's always a bit of difficulty with the rule of law issues around what was considered a crime then and what is considered a crime now. But the very first step would be to remove these statutes of limitation that say we can't go back at all. We can't go back beyond a certain time. But this not only affects criminal matters, but also civil matters, because in many instances, one can't sue for harms that happened a long time ago. So one has to be able to remove those barriers as well. So these are recommendations that the Committee on the Rights of the Child will be making to states parties in this general comment. As I've said, I think those of you working in this space really please do look at the draft general comment and make your comments. You may find it's too general and not specific enough to your issues. I know that will be a frustration for you, but just try and see where you can insert as much as you can to bring your experience to the fore and to show and to make sure that we open the gateways for this kind of access to justice. Another last thing that I want to say, moving off the general comment and off these issues of the bigger, large-scale interventions, but that is, I want to remind everybody about the optional protocol on a communications procedure of the Committee on the Rights of the Child, because I think we should not underestimate that this could also be used by people who have tried and failed at the domestic level to get the redress that they need. Because if that state is a state that has ratified the optional protocol, then it is possible to bring a claim. One of the barriers to bringing a claim to under the Convention on the Rights of the Child will be this issue of the ongoing violation. In other words, if this is an old historic claim, if it goes back before 1989, it will be very difficult to bring it because the convention was only adopted in 1989. But then one can look at the violation, the ongoing violations aspect, to overcome the fact that, okay, this happened when this person was younger than a child. They're not children anymore, but it's an ongoing violation. This would be an interesting breakthrough in the jurisprudence of the committee. So it would need to be very well argued, but I think it can succeed. An easier route might be to go to one of the other committees that doesn't have this problem. It doesn't matter if you're a child or an adult if you're claiming, but then you'd have to be claiming under those covenants or conventions. So this is all just part of the conversation going forward, I think, about the different avenues of access to justice that can be brought. And I'm looking forward to research that is being produced, which Mia Dambach is involved with as well, in looking at some of these large-scale interventions. And so I'm thinking that there will be a lot more comparative evidence in coming years about what works and what can be done better. So I will leave it there and look forward to the rest of the discussion.
Thanks for that, Anne. We're very much looking forward to the draft general comment being out in a couple of weeks, and we will share it widely to get comments from people who are working on not just identity rights, but more broadly. I'm sure that people are very keen to see how it can help us with our work. I don't see any questions for anyone in particular, but I have my own questions. So for Linnell, Arthur, Audrey, Patricia, what I would be interested in hearing is what would be your recommendations, giving a bit of detail to what Anne has just talked about in terms of reparations. What do you think could be something very specific that states should do to make sure that this access to justice is more accessible for children, and it is also going to cover this ongoing violation of children's rights that Anne has spoken about? And maybe a question for you, Anne, is I haven't looked at all the OPIC decisions, but could a group of children come to the committee for a past violation to say that this is an ongoing abuse, something like all the Indigenous children in Australia that had been forcibly removed from their families, or from Canada, or a group of donor-conceived children? One thing is, can a group do it? And could multiple countries come with the same complaint? So a whole group of inter-country adoptees, someone from Australia, someone from Switzerland, someone from France, but could they all come? I don't know if that's possible. I didn't look to see whether that would be possible. But anyway, over to you first, Linnell, and then Patricia, then Audrey and Arthur, and then Anne. Thanks.
Well, now you put me on the spot, Mia. So yeah, I think the most important thing that states need to do in terms of adoptees is actually addressing the lack of legislation that allows the illicit and illegal practices to actually be considered human trafficking. That is our hugest problem, is that we don't have any definition that actually in legislation and structure of a framework to be able to even be recognised as victims. So it's a huge, huge issue globally. Yeah.
Okay, thanks for that, Linnell. Definitely legislation is lacking in all the countries. Even this basic, like Patricia talked about, she spoke about it, even access to birth records, that only came into place 2022. That's so basic. But anyway, Patricia, what would you think? What would be something that you would do?
Thanks, Mia, and thanks, Anne. Really interesting commentary and reflection. I would agree with Linnell. From my perspective, the work I'm doing, I think it's open access to records, like completely unredacted. And that includes the records of the institutions that were, I suppose, this hierarchy of confinement, or this architecture of confinement, to understand the payments, to understand the administration. For example, the Magdalen laundries in Ireland, they were doing the laundry of our president, you know, like, how did that happen? So to understand the structures, to open the records. Something I'm involved with in Ireland is we're actually building a site of conscience to remember and do research on this for all of those people who were in institutions and removed from their families. And that speaks to the principle of non-recurrence. I think that's something that, you know, we need to talk about. If you look at the current human rights and identity violations, inclusion in school curriculums, we're terrible in Ireland for talking about famines and wars, but we don't talk about what happened in our own country. So I'm pushing really hard to get this history into our curriculum so that younger people understand what happened. That's what I would say. Thank you.
Thanks for that, Patricia. And Arthur and Audrey, maybe you want to show your slide, but you're on mute, Audrey. Audrey, le son est coupé. Je vais juste...
Sorry. Just say that there are old and constant recommendation, but states must implement measures to ensure the effectiveness of rights. States must ensure that parental secrecy and anonymity are time limited. They must allow children to know their siblings, and enable them to access their biological parents' medical history, to limit the duration of storage and the use of gametes, and to, as Anne Skelton talk about prescription, I can say. I am familiar with French case law on the subject, but since I discovered I was over than 18 when I was able to invoke the CRC, couldn't we argue that we have the right to rely on it? And, you know, do you think we can move something on this very strong French case law that say when you are over than 18, you can't rely on the CRC? But, you know, there is a principle in French law that say there is no prescription if you didn't know that there is a prescription that is going on. I don't know if it's clear. You understand, Mia?
I do. I do understand, and I think Anne understands, and she can answer that question as well.
Okay, what do you think, Anne?
Well, I do think that one can rely on the CRC after you've turned 18. But for me, it is this question of whether or not you can make the case that there is an ongoing violation. In other words, that the effects of what happened to you when you were below the age of 18 are continuing. Then you can invoke the articles under the convention. This is my view. It is, I would say, though, very difficult if the violation occurred before 1989 when the convention came into operation, because then there's no basis. The convention wasn't there at that time. So one would have to look at what was, I mean, there was a declaration, but it wasn't a binding instrument. So I don't think one can go back that far, but I think one can say, so I'm surprised. I was surprised when you said that the European Court of Human Rights, or was it the French court, said you can't invoke the CRC after you turn 18. I think that's an overly simplistic. Yeah. And I think it requires some revision. So that would be my answer on that. And I have some answers to Mia's question about using the optional protocol on a communications procedure, which we call OPIC. So it allows for two different kinds of process. So one is individual communications. And as the name of it suggests, it is for individuals or groups of individuals to bring a case to the committee for specific rights violations. It is possible to bring a case for a group of children, but they do have to be identified at least in some way. So the committee had one case, for example, where children were in a children's care facility, And the ombudsperson, this is in the state of Georgia, couldn't get access to the children, so therefore couldn't identify them by name or whatever, but it could say, I'm bringing this on behalf of the 28 children in that institution. That's a sufficient identification. Or, for example, the children in the camps in northeast Syria, the ISIS-related children, not all their names and dates of birth were precisely known, but it was still possible to bring a case on their behalf. Their grandparents, this is a case against France, brought the case and specified sufficiently. So that's part of the answer, Mia. But there is also another process under OPIC that one can use, which is an inquiry. And the interesting thing about an inquiry is it can be a request from any source of information. So it could be an NGO, it could be a group of individuals who have got together to form some kind of collective around an issue, and they could then report this to the Committee on the Rights of the Child and ask them to investigate a grave or systematic violation of children's rights. And the interesting thing about this type of inquiry is that it doesn't require the exhaustion of domestic remedies, whereas the individual communications, you have to first attempt to exhaust the remedies at the domestic level before you can come to the Committee on the Rights of the Child. You must at least show that you have tried to do so. The question about, so essentially it is possible to bring on behalf of groups. It is under inquiries, not under individual communications, unless the group is identified. But you can't bring a case on behalf of all children who were adopted between this year and this year. That would be too vague, except for an inquiry, but for individual communication, not. But the interesting thing is that the remedies, on the other hand, can be collective under this principle of guarantees of non-repetition. So, in other words, there's always some form of reparational redress for the individuals who brought the case. And then, in addition, in order to prevent future harm, one can do all of these other things as well. So I think the remedies under OPIC are quite flexible, and one can be quite creative in expanding the remedies so that they are collective, even though you can't actually bring a collective complaint. I should just mention, by the way, that under the African Charter on the Rights and Welfare of the Child, you can bring a collective complaint. So that's another avenue that could be explored, but only for African countries. And all African countries that have ratified the African Charter are eligible to have cases brought against them as well. So that's an interesting angle to explore, perhaps. So I think that there are some possibilities in using these all the treaty body communications procedures, but if we want to use the CRC, it's the frameworks that I have described. I think there's a lot still that could be explored and could be done, and including people who are currently children who are wanting to get access to information and are being met with a stone wall. They could also, obviously, for them, it will be much easier to bring a case under the Convention on the Rights of the Child, but I think not impossible, and an important principle to establish that one should be able to bring a case if you can show that the violation is ongoing.
Thanks, Anne, for that. That was very clear. I just wanted to say if Linnell, Patricia, or Audrey, we have Anne here with us. I let them ask you one question each. Instead of asking a state, the states always give us the same answers. I give Linnell something different. Do you want to ask Anne a question, Patricia? And Audrey, ask away, she's here. Linnell first.
I was going to say I'll let the others go first so I can think what I want to ask. But I found that fascinating, Anne.
Yeah.
Thank you, because I'm going to make sure all the adoptees hear the recording of what you've just shared, because it's very useful. Thank you.
It's more a comment than a question, but I suppose I'm really interested in the broader European and world analysis of what's happening, and certainly from the adoption world, I'm sure Linnell will agree, it's really only in the recent past that we are empowered to talk about the harm done in terms of inter-country adoption. And I'm really glad that we're now having conversations around anonymous, in fertilization, what Audrey and her husband talked about, but also surrogacy, which I know is a completely other area, but I just have so many concerns, and I feel it's quite a taboo subject to talk about. It's more a comment, but I'm really refreshed and energized by hearing the worldwide conversation. So thank you all.
Arthur, and thanks for that, Patricia. Arthur and Audrey, do you have a question? Because if not, we just had 3 questions from the group.
No, we don't have. I also have. I have already asked my question, and just to answer you, and Skelton, it was French court that said that I can't use the CRC because I'm over 18, and it's a constant case law in France.
Excellent. Thanks, Audrey. I have a question, and I think I'll ask it firstly to Anne. It's from Marilyn Corshaw. What does the panel think about the responsibilities for birth registration to record accurate information about the biological genetic parents? Because in surrogacy, a number of countries allow the recording of intended parents as the legal parents, but there's no information about the donor conceived the donors or the surrogate mother necessarily. And also a question from Chipo Mukuko, thinking about the principle of non-repetition. I'm curious to hear about your thoughts about child rights informed interventions. When at an early stage, when decisions are being made to use assisted reproductive technology to start a family. So maybe what do you think, Arthur and Audrey, what do you think intending parents should be told from the word go about what's going to happen about the children? And then another question is about, and I think this is more about conflict and post-conflict situations. How can we, what are the challenges in these situations? But Anne, you would know this because you've seen quite a bit of this in your work with the CRC. Okay, so let's over to Anne. No, Audrey first, and then Anne, you can finish the webinar.
I'm not sure. The question is that what the intended parents should know, should know, we would like them
about?
What?
What should they think about when they're going to use third-party reproduction? What kind of information should they have to make this decision in terms of the child?
I think they should be trained with the idea that the child will probably ask some question, and that he will probably would like to have information and maybe the identity of the donor, and that they should think about it and take this into their decision, and we would like them to have medical information, because for the medical I don't know for the when for the child, and to know if there is a problem with the donor, what is the medical history of the donor, and we also would like to limit the use of gametes during I don't know, maybe 20 years, because otherwise they will have a problem with generation. You understand?
Yep.
So you
Yes,
want to
but
complete?
we had a debate with Anne Skelton about it, and we spoke about not 20 years, but 10 years maximum.
Yes, yes, I think it's a lot. And anyway, I think just you know, when we were conceived with Arthur, it was the secret, and you know, they went to the hospital to find gamete, and nothing asked. There is no question. We want a baby, and that's all. And but the baby is growing up, and he's asking some question, and each parent should know it before, and should be sensitive of talking the real history of his child.
Thanks for that, Audrey. I think that that's a great way to end. It's to know the truth about the way you were created. And Anne, to answer Marilyn Crawshaw's questions about the way surrogacy is occurring at the moment.
Well, I think, you know, what we need to be clear about is that under the Convention on the Rights of the Child, children have a right to the preservation of all information that relates to their identity. And this is a state obligation. So states should, in terms of things like birth registration and the recording of information and so on, it should never be recorded in such a way that obscures the truth, obscures the right to know, to preserve identity and to have it known. And so I think that there is a lot of reform that is required to make sure that we recognize that. And it's interesting, civil and political rights of children. Maybe we made too many assumptions at the beginning of the Convention on the Rights of the Child that was understood that children have civil rights, because we put a lot of effort into explaining that children have social and economic rights. But actually, I'm realizing we need to stress children have these rights, and that really states need to make sure things are in place. As far as parents are concerned, of course, the Convention on the Rights of the Child is aimed primarily at states' obligations. But at the same time, I think it's important for parents, intending parents, to know that that children have a right to have all information about their identity preserved and made available to them at some stage. I would say during childhood. I'm always interested to see that Audrey and Arthur are very, very modest in their claim that it's only until the age of, at least from the age of 18, people should be able to access information about their origins. I would say younger. I would say during childhood. If the child wants that information, then it should be made available to them. But of course, we know it's tricky, and that children might need different amounts of information as they're growing older, just as they do about their, just as we teach children about where do you come from, how were you made, how were you born, we give them little bits of information about these things as we go. So I think it does require special knowledge about how much information children can manage at different phases of their childhood, about how much information they will be given along the way. And I think that parents need a lot of support in this. Now, when we're talking about adoption, they might be being provided with that post-adoption support in some states. But when it comes to surrogacy, there won't be. So surrogacy is, big on the agenda. It's just like a private arrangement. And I suppose the same was true for donor-conceived children, within partnerships. There was no follow-up. There was no advice. There was no support. And so, but that's probably true in many adoptions as well. So all in all, we can see that there needs to be a sea change in understanding that this right to know origin starts in childhood, and we should be getting much better at how to provide children with that information in a phased way as they grow older and older. yes, obviously from the age of 18, you should be able to access all the information. But as I say, I would keep the door open to arguing that that should happen earlier if it's requested.
We agree.
Yes, I know.
Definitely, you know, yes, we are more moderated, but nothing works. And so, and we agree, just because it's very difficult in France to move lines to.
Yes, so it was your strategy to be moderate.
Yes, but I
Yes.
think it doesn't work. That's why. And anyway, we agree. If I think so 15, 16, anyway, you know, when you are a young adult,
Adolescent.
you started to ask some questions. So that's the moment to give information, to give answers.
Excellent. Well, I think that we've had a very productive webinar. We've had the best speaking about these different topics and tackling these family relations from so many different angles. We can see that it's an issue that's not only from the past and the way past, but also in the present and also into the future, because a lot of you have spoken about the intergenerational impact. It's not just about the child today, it's about the child's children and into the future. We can see that it's affecting not just individual cases, but mass number of children. And so it shows us that there is a lot of work to be done. And I'm very thankful to be having you in this field to work with us on this, to make sure that every child can have access to justice and effective remedies. But hopefully we can avoid that and we can just give them access to their right to identity, full stop, from the beginning. So thank you for that. And the recording will be on our website within the week, and we will continue to share information with you all as we move forward. Thanks again. Bye-bye.
Thanks a lot.